All right, hi. Sorry about technical difficulties. Let's get going. This is some of you might have seen this presentation before. I'll try to make it a little bit different, but I'm not totally sure. I did about 2 years ago, or just under 2 years ago, for TB vets. It's estate planning for blended families, so some of this might be review to you, and that's okay. We are assuming some things that you know just generally about estate planning, so that you know what a will is, you know what a power of attorney is. There's some general knowledge from prior presentations. So if there are any like fundamental questions like that, we can get into it, but I think you should be acquainted enough. Okay, my general disclaimers. So all of the information in this presentation is just general about estate planning for blended family. It's general, it's not specific legal advice, so definitely seek your own legal counsel if you want. Lawyers are risk adverse. I mention this because when you talk to a lawyer about your own estate planning for your blended family, they may suggest things that actually don't make sense for you. And we're going to often warn you about all the awful things that might happen. And I'm going to warn you in this presentation about some awful things that might happen. But that doesn't mean those things will happen or even that they're particularly likely to happen. So listen to your lawyer's advice. Remember, they're coming from the most risk adverse position possible, really. But ultimately, it's your choice whether you take the risk or not. You can never fully avoid risk in life or in law. So often it takes more time than it's worth to reduce your risk, and that's your choice. So just keep that in mind. So you have risk adverse lawyers, but ultimately it is your decision as to whether you take risks or not. Photos in this presentation are not of real people. And as I said before, we are assuming some basic estate planning knowledge here. I'll go over some key terms really quickly, just in case you haven't been familiar with these before. So in this presentation, the last will and testament, or will, that is the document that distributes all of your assets, all of your property on your death. You might hear me refer to assets or property in this presentation. They mean the same thing here. It means everything a person owns, whether it's real estate or not. I mention this because often clients get confused that property only means real estate. In the law, we use property refer to anything like your pencil, your car, your everything you have is your property. So I just wanted to make that clear. And then we have joint tenancy or joint ownership. This is the kind of ownership where two people own 100% of an asset together. It's called the right of survivorship. So if you and your spouse are entitled to your property as joint tenants, it has nothing to do with renting. It just means as joint tenants means you own together that house. And if one spouse dies, then it automatically, the entire house passes to the surviving spouse. In contrast to that, we have tenancy in common or ownership in common. That is when two people own 50% of an asset with no right of survivorship. So if you and your spouse own your house as tenants in common, that means that you own 50% and your spouse owns 50%. And you can pass your 50% however you want. So in your will, if you said it's all going to my kids and that are not shared with my spouse, and that's what happens with your 50%. Your spouse's 50% can go to different beneficiaries. So that's the distinction between joint tenancy and tenancy in common, which is important. A lot of people don't understand the distinction between these, which can lead to some messy situations, or they don't know how they hold their assets. Wills variation. So this is a big shocker to some people, hopefully not for you who've seen some of my presentations before, but under Section 60 of the Wills, Estates and Succession Act, you can challenge a will. So even, well, not you, but some people can challenge a will. So even if you are fully competent when you make your will, even if you are, being what you think is fair, your children or spouse can make an application to overturn your will and have the court decide on a different distribution. So it's the most comprehensive variation law in Canada in British Columbia. So unlike other provinces where You might have it only impact families where the children are still minors. Our wills variation in British Columbia continues until after the children are adults and independent. So as you can see, it would often occur in blended families where you have a conflict between often the second spouse and the children of the first marriage. It's a right of a spouse and the children to apply for this, and it's distinct from a family law claim. So keep that in mind. Doesn't necessarily mean if someone's making this claim, so let's say your second spouse is making this claim against your estate, it doesn't necessarily mean that they are entitled to half of everything as they would be in a divorce claim. Some similar analysis can often apply, but the court is going to be looking at different standards. There's a whole range of results that can happen in a wills variation case, anywhere from a second spouse receiving, only an additional 10% to the former spouse receiving much larger amounts. So wills variation. So who is a spouse? So we're going to talk about who can challenge under that particular section of the Wills, Estates, and Succession Act. You've probably seen it there referred to as WESA. It's often the way that we lawyers talk about that piece of legislation. So who is a spouse? It's important to know who your spouse is. Obviously, if you're legally married, that's pretty clear. But the one that we have now in British Columbia that people often get confused on is if you're living together for 2 or more years in a marriage-like relationship, that is a common law spouse for the purposes of WESA. There are different timelines for other parts of the law. So you might have said, oh, well, I thought we were spouses after 6 months or a year or whatever the case might be. There are different timelines for when that common law relationship becomes a common law relationship for different parts of the law. So for tax status, I believe it's around 6 months. For other parts of the law, it's a year. For the parts where I'd say it matters a lot is WESA, wills and estates, it's 2 years. And also for divorce or separation rights, it's also 2 years. So the spousal relationship ends when the couple lives separate and apart with the intention of ending the relationship. And note that if you are legally married but separated from your spouse for a long time, they could still have a claim against your estate if you haven't settled your family law matters properly. Okay, so when do you know? So if you're legally married, it's pretty clear you're married to each other, your spouses. But what do we think about when we're deciding if people are in a marriage-like relationship, in a common law relationship? And I find that some of my older clients get caught on this, not thinking that their partner, from their second partner, is going to be entitled to anything because they're not legally married. So there's no determinative checklist on what constitutes a marriage-like relationship. So the court has said there's not one determining factor or several determining factors that definitely is a slam dunk that is or isn't a marriage-like relationship. Overall, the court is going to look at, and when I say the court, we're not necessarily meaning that all of these situations that we're discussing are actually going to court or they're being adjudicated by the court. The reason I refer to the court or what the court might think or would think is because, as you probably know, the law is based on case law. So it's based on what the courts have said in prior cases. And so when we talk about what the court would think or what the court would say, we imagine that or we consider that because what the court might or would say if this matter went to court helps guide our thinking and our solutions on how we'll solve it without going to court. So I just want you to be clear that going to court is very expensive, stressful, time consuming, and it doesn't happen all that much. So it can happen, but 99% of cases do not go to court. They settle long before then. And so yeah, no, I just don't want you to get the idea that when I say the court or I consider what the court might say, that's not that these cases are actually going to that level. It's just that's our legal framework for considering the problem. So if something were to go to court, the court is going to consider what the couple demonstrated in their relationship in accordance with contemporary society. So the things that contemporary society associates with marriage, and that can change over time as our values in contemporary society changes. So the things that, we thought 10 years ago were indicative of marriage might no longer be, or those factors might change. So as of now, there are some common factors that the court would say our contemporary society considers to be indicative of marriage. And I'm going to show you what those are on the next slide. So yeah, so the court said there's no checklist, there's no determinative checklist. So that's why I say none of these factors are determinative. But it is important to consider these types of things because these are the things that the court would look at. So are the parties living at the same residence? Is there sexual intimacy, sleeping in the same room, domestic chores being shared, taking trips together? This one I consider a big one, actually. I know there's no determinative factor, but recognition of a couple as a couple by family and friends can be a really big one. So if you have a new person in your life that you're introducing to your family and friends as your partner, rather than as someone you're seeing or someone you're dating or a boyfriend or girlfriend, that can be indicative of a more serious relationship. And that's when I often say to clients, do be careful. I know that partner has kind of been the catch-all term, a nice gender neutral term for someone that you're in a romantic relationship with. But do be a bit careful on using that term because in the legal context, that indicates a more serious relationship than just a more casual or dating relationship. Expressing affection, making major decisions, shared property. You can see all these things. So all of these factors are considered when deciding if someone is in a marriage-like relationship with another person. This one is a fairly recent case that we've had. Before this case, we used to think, okay, as long as you're not living with your romantic prospect, you can't be said to be living together in a marriage-like relationship. Well, since this case, the court has said, actually, no, there are circumstances in which you might not be living together, but you are still in a marriage-like relationship. So this was a case involving two women that were in a relationship. It was a long relationship. You can see from 1990 until 2000, breaking up and getting back together. In this case, the court said that the significance in attending family events together and having a very strong emotional attachment, domestic labor, major life decisions, those were all important factors in determining this was a marriage-like relationship, even though in this case, Maria and Barbara never lived together. And they also considered that because of their sexual orientation and their religion, they were not able to live together with their cultural context as they might have done otherwise. And so the court said this is a marriage-like relationship, even though the parties don't live together. So keep that in mind. What I've taken away from this is that if there is a reason, like sort of an external reason that the couple cannot live together, that can be a factor in saying even if you don't live together, you're still kind of you're still together. Another example would be like working because of distance. So one person lives in Victoria, one person lives in Kelowna, but they do like share a life together. That also could be another situation where there is still a marriage-like relationship, except even without living together. Okay, so we're going to move on from spouses here to talk about children. This is usually a little bit more clear. So it's legal children only. So the only people who have the right, and remember, we're tying all this back to who can challenge under that provision of WESA, the Wills, Estates, and Succession Act. So it's your spouse, either legally married or common law, and it's your children. So it's your legal children only. So your biological children and children that you've legally adopted. Stepchildren do not count. So your stepchildren that you have not legally adopted cannot make a claim against your estate. And vice versa, if you have children that are not in common with your spouse, those children cannot claim against your spouse's estate. Um, and then if you have biological children and they were legally adopted by other parents, then they're not your legal children anymore. So you don't have a claim. They don't have a claim. They would claim against their legal parents' estate. And then just a note here, remember that adult children can make a claim even if they're financially independent, which some people are really floored by, that, you can have a child in their, in some cases of people living longer in their 60s or 70s, the adult child is making a claim against their 100-year-old parents' estate. Seems pretty crazy when, you've been an independent adult for so long, but that is the way it is. So okay, so when we're looking at a blended family, we're looking at how do we balance the different claims, and the claims that we often consider when we're making a plan. So we're trying not to have any claims against the estate. We're trying to make a plan that's going to keep our family happy and not in court. We need to look at the spouse and the children. As I said earlier, it's often the second spouse versus the children of the first marriage, not in terms of a court case, but just those are the balance. That's where you're thinking, okay, I have to provide for my spouse and I have to provide for my children. So you're looking at the legal standard is a prudent parent. So what would a prudent parent do in that circumstance, considering their spouse, considering their children? You're going to consider the needs and means. So what needs does your family have, and what are the means that they have of providing for those needs? The spouse is going to have a greater entitlement. The courts have said the spouse has both a legal and a moral entitlement, meaning that, if you were to divorce your spouse has legal rights in divorce law or separation law. And they also have a moral entitlement, meaning that, it's just a generally understood thing in our society that you're going to provide for your spouse when you die. Independent adult children have the courts have said, only a moral entitlement, which I think really derives from the fact that, during your lifetime, your adult children cannot sue you for your property. Like, they don't have a legal right during your lifetime. But after your death, they do have this moral entitlement, which essentially extends to a legal right after your death. And the court can award. So the court, if your family matter was to go up to court, the court would choose an adequate provision for your family. So the court would decide, I don't think the will of Bill was fair to his second wife. I am going to decide that she is going to get 50% of the estate or 30% of the estate, or the court will decide based on the facts what it considers appropriate. And remember, this can really exceed what you think would be adequate. So in the normal sense, we would say, okay, well, adequate provision is the person's not, they're not on the streets, they've got a roof over their head, they've got food, they're provided for, fine. That seems adequate to me. In a wealthy estate, in a large estate, the court often will award far more than what anyone would consider adequate. So in one of the top cases that started off a lot of this law, the court ended up awarding the first spouse an additional $2 million. So we're not necessarily talking about, just enough to get by. We're talking about well in excess of that. Okay, so here's some considerations that I'd say you want to think about when deciding what to provide for a spouse. So if you're thinking, okay, well, how would I provide fairly for my spouse? You would say, what would they get if we did separate or divorce? This would be, half of all the family property, which can be substantial. And I'm not going to get too far into what family property is, because it's actually it's not just half of everything that you have as a couple. Some things are excluded from that, but generally it's a good starting place. And then you'd think of, what would the spouse have received if I hadn't made a will? So this is what happens if there's an intestacy, you didn't make a will. It would be a preferential share. So it would be $50,000 plus half of the estate. So that's actually a little bit more than what they would receive under divorce law if you died without a will. So those are kind of the frameworks that you want to think of is, okay, half or a little more than half, you can say would be essentially standard. That would be sort of the standard provision for your spouse. You don't have to do that. You can provide for less, but we're going to talk about, other things you consider. So you consider the length of the marriage. Can your spouse provide for themselves after your death? What was their lifestyle when you were, what is their lifestyle now? So are they going to be accustomed to a certain way of life? The needs of the other beneficiaries, source of the estate. So did you accumulate your assets during this marriage or after or before this marriage? That can make a difference. So you might say, okay, well, I have $3 million, but I accumulated most of that money with my first spouse. My second spouse that's only been around for the last 15 years. I didn't acquire that wealth with them. That might be an important consideration. And you might consider other gifts or assets that your spouse has. Another one here, which I haven't listed, is a prenuptial agreement or a cohabitation agreement. Of course, if you have one of those, that often is going to address like what your spouse, your second or subsequent spouse would get after your death. And so that is a big one. These are more considerations that I would list when you're thinking about making a cohabitation agreement or a prenup, or if you have not made one. So you have never made that and you're now considering what to do about your second, third, fourth, subsequent spouse. Okay. What do you think about with your adult children? So similar things, you consider reasonable expectations that they might have of inheriting. We talk about the source of the estate again. So again, if you accumulated most of your estate, most of your assets with the parent of your adult children, your first or an earlier spouse, your children are likely going to have a fairly high expectation that that money is going to be passed on to them because their prior parent helped with that as well. Ability of the children to provide for themselves, their sacrifices, all these kinds of things. If there was an estrangement, whose fault was it? The court tends to really put a lot of the blame on the parents for an estrangement. So if your child has cut you off and not talked to you for a long time and it's not your fault, you've tried to make all best efforts, it's a good idea to keep, and you don't want to provide for that child equally with your other children. It's a good idea to keep a record of how that estrangement occurred and document like your attempts to resolve, as the parent, resolve that estrangement, so that it's not sort of placed on you possibly in the end that like you caused it, because the presumption tends to be that the parents caused the estrangement. Gifts to children made prior to death. And then just a note, it is very difficult to absolutely disinherit a child. So let's say you're not so concerned about your spouse, you think your spouse is going to be fine, but you're thinking about your 3 kids and one of your kids hasn't talked to you for 20 years. And you say, I don't want this one child to inherit anything from my estate. We haven't talked in 20 years. Absolutely disinheriting that child is going to be a challenge. You might succeed on providing that child with less, with documented reasons for how the estrangement occurred and that it wasn't your fault. But to absolutely cut someone out is going to be difficult because almost certainly that estranged child will succeed in getting something out of your estate. Okay, I'm going to take you now through what I call my common conundrums, and there are 3 of them. And these are basically common situations that I would see in a blended family when they come to do their estate planning. So I'm going to talk you through what these facts are, and then we're going to look at some legal tools that we could use to solve these problems. And keep in mind, like the solutions that I'm going to suggest, they're not necessarily like ironclad legal advice on what absolutely you must do in that situation. It's one of a range of options that could work for the couple. So number 1, we're going to talk about Fred and Mary, the long second marriage. So in my little fake fact pattern here, Fred and Mary are in their 80s. They married in their early 50s. They've been married 32 years, so a long marriage. Fred has 2 adult children from his first marriage, and Mary has 1 son from her first marriage. They were young adults when Fred and Mary got married. Fred and Mary do not have a marriage agreement, aka a prenup, so we know that there's nothing set already as to how this is going to work. Fred and Mary both worked during their lives and retired in their mid-60s, so they both contributed to the family assets. All assets are jointly held between them. So what that means, if you go remember from one of my earlier slides, they are joint tenants. They jointly own all of their assets together, so that when Fred dies, Mary automatically would inherit everything. And it wouldn't, another thing I should mention about joint tenancy, I probably should have done it at the start. So let's say Fred and Mary own their home together and their bank accounts together, they own them jointly. When Fred dies, everything automatically passes to Mary with no reference to Fred's will. Fred's will is not involved. Everything just goes straight on to Mary. Okay, and Fred and Mary want to make identical wills, so they want to make everything left to each other first, and then 50% to Fred's kids and 50% to Mary's son. So that's their general situation. Okay, so we're gonna just remember these facts about Fred and Mary. We're gonna leave them for a second, and then we're going to see how we can address the situation. But generally, the problem here is that if everything passes to the survivor, so if Fred dies first and everything passes to Mary, there is a chance that Mary could disinherit Fred's kids, or vice versa. If Mary dies first and everything comes to Fred, Fred could disinherit Mary's son. And they might trust each other. They might say, well, I know that Fred isn't going to disinherit my kids. Mary's not going to disinherit, but there could be a second spouse, possibly. Some people have late in life second partnerships, and that could result in a problem in the inheritance. So the general problem here is that Mary and Fred hold everything jointly. They want to leave everything to each other, but there is not protection for each other's kids as against the step parent or against future marriages of that step parent. Okay, so our next common conundrum, here we have Laura. Called this the intent to prioritize children. So Laura is 60 years old. She's recently retired. She's been living with her boyfriend, Paul, for 5 years. Laura is significantly wealthier than Paul, and she's got 2 adult children from her prior marriage. Paul has no children. They do not have a cohabitation agreement, so they never discuss these matters. Laura keeps all of her assets separate from Paul, including the home they live in. And Laura intends to make a will leaving Paul the right to live in the home they share for 2 years and then leave the rest to her own children. Okay, so Laura's plan probably makes sense to a lot of you. So why would she leave that much to her boyfriend of 5 years when her children are more important? Most of her assets would have been earned before she even met Paul. However, if Laura goes through with this plan, Paul could have a claim against her estate. So Paul would likely be able to succeed in proving that 2 years in the home is not adequate for him, especially because he's less wealthy than Laura and he probably depends on some of her wealth to support his lifestyle. And for each year this relationship continues, Paul's claim becomes stronger and stronger as against Laura's estate. So this plan, well, it might seem very rational, very logical, there's some additional protections Laura is going to want to have in order to ensure that this will work out. Okay. Common conundrum number 3. So complicated children, Yasmin and Tim. So in this example, we have a couple been together for 27 years. They each have children from prior relationships, which they raised together, and they also have one biological son together. So they have 3 children they've raised together. All the children are now adults. But the husband in this couple, Tim, he has another son, David, who was much older when the two of them met. He's the son from Tim's high school relationship, and he's been raised entirely by Tim's ex-girlfriend and her family. Tim hasn't seen this other son as frequently, more like 3 to 4 times a year or once a year since his son's been an adult. This couple, Yasmin and Tim, have some joint assets and they've got some separate assets. So they each have $500,000 separate and $250,000 together. They want to make identical wills, leaving $25,000 to David. And so that's Tim's son from the earlier relationship. So they just want to leave him $25,000. and then they want to leave everything else to the other. And on the death of the survivor, everything would be divided equally among the children that they raised together. So their biological son and their two children together. Oh, sorry, I messed that up. Here we go. So what are the problems here? So the problems here, again, we see that not all of the children are in common. So both Yasmin and Tim have obligations to their biological son together, George. But Tim only also has obligations to his other son, David and Amy. So their obligations are different, basically because of the step parent situation. So let's assume that Tim dies first because he's older. So when Tim dies, his $500,000 that he holds separately from Yasmin will fall into his estate. And out of that estate, David would get his $25,000 off the top. So the son from the prior relationship would get 25,000, and the rest would go to Yasmin. However, David, the son from the prior relationship, has a good claim that he should get more from Tim's estate, much more from his dad's estate, than that paltry $25,000. So unless David has done something totally egregious, it's presumed that Tim would treat David the same as his other children. And he actually might have a pretty good claim because he has an argument that Tim wasn't as an active parent to him as he was to his other children, George and Amy. So that is a problem. Okay, so assuming in our example, Tim dies first, the rest of Tim's estate is going to pass to Yasmin. So $25,000 to David, everything else to Yasmin, unless Amy, who is Tim's other biological child, also takes issue with that. So Amy could say, excuse me, I don't want everything going to stepmom. Even though like she raised me, I don't have legal claims against her estate, and it could eventually lead to Amy receiving less. So that's a problem too. So as you see, yeah, having complicated children from different relationships at different ages can be a big problem, a common conundrum. So we're going to talk about some legal tools here that we could use to solve these conundrums. Cohabitation or marriage agreements, also called prenups. We've talked about these before. You can still make one of these even after the marriage or the relationship has already started. It's more difficult to make it, but it can be done. We're going to talk about severing assets, which essentially when you own assets jointly, changing that ownership so that you no longer own them jointly. You own your half, your spouse owns their half, that way. We're going to talk about excluding assets. I'll talk about that on our slides, a bit more complicated. We're going to talk about some trusts, some mutual wills, and statutory declarations or explanations. So I'm going to go through each of these here. So a cohabitation or marriage agreement. So it is the agreement between the spouses regarding how the assets will be divided if the couple separates or if one of them dies and they're still together. And it's easiest to enter into these when the relationship is starting. So early in the relationship, you enter into one of these and you work out whose is what, who has what obligations, and who will inherit what when. It's a contractual right, which means it's not based necessarily on estates law. It's based on the contract that you sign together. The court will not necessarily absolutely follow the agreement if circumstances have changed, but it'll be given a large weight, especially in a subsequent marriage. So in a first marriage, if two young people, excuse me, enter into one of these and they say everything that's mine is mine, everything that's yours is yours. And then 20 years pass and they have kids together and things have totally changed. That agreement is less likely to be upheld. But for a subsequent marriage, second or third marriage, where the parties are fully adults, they've earned most of their assets, they have children that are not in common, these marriage agreements or cohabitation agreements are a very solid way to protect assets. Severing assets. So I talked about this before. This is removing assets out of joint names so that assets pass to the estate rather than directly to the survivor. So I usually use the example of an orange, slicing the orange. So if you imagine an orange, and you imagine that you and your spouse own that orange together. You together own that 100% of the orange. And if one of you dies, the other one gets to have the entire orange. You own it together. You don't get to decide what happens to your notional half of the orange through your will because you own that orange together with your spouse. If you die, your spouse receives the orange. Severing assets is slicing the orange. So it's saying, yeah, we owned this orange together, but that no longer makes sense. We're going to take a knife and we're going to cut this orange right down the middle. So you have your half of our assets as a couple, and I have my assets that we had as a couple. So my half of it. And then you can leave your half of the orange can now be passed down to your family, and my half of the orange can now be passed down to my side of the family. This can be done secretly for some assets. So I've had clients secretly slice the orange for real estate assets without telling their partner. They basically sign a transfer from themselves to themselves. That sounds weird, but it can work out that way secretly. Bank accounts, you would have to have the permission of your spouse to sever, to move half into their sole name and half into your sole name. Okay. It doesn't necessarily protect against all claims, but what it ensures in this case, this would be a good example for Fred and Mary, our first couple who have everything jointly. If Fred wants to make double sure that his assets go to his kids and Mary wants to make sure of the same, they could decide to sever their assets. So cut their assets in half. Mary makes sure that hers eventually goes to her kids. Fred makes sure that his eventually goes to his kids. Okay. Excluded assets. So these are assets that actually do not pass through the will of a person. So many people think everything when they die passes through their will. That's not true. There are certain assets that pass outside. So joint assets that we just talked about, that's one of them. So if you own an orange together, it passes automatically to the other owner. But it also includes tax-free savings accounts, registered retirement savings plans, and insurance policies. So anything that names a direct beneficiary, that does not form part of the estate. It goes directly to the beneficiary that you've named. So those assets don't form part of your estate. They don't pass through your will, and so they can't be subject to variation. So a good use of these is to make sure that whoever you've named on there is your intended beneficiary. So let's say Fred and Mary, they're worried that, Fred is worried that his children might not receive an inheritance if he leaves everything to Mary, and then she might disinherit his kids or get into another spousal relationship where that spouse disinherits his kids. He could say, all right, I'm going to make sure for my tax-free savings account or RSP or RIF, if he's already drawing an income from it, I'm going to change the beneficiary to name my kids so that I know at the very least that asset is going to go to my kids, not to Mary and not to potential issues with Mary's estate. So that's another tool. Alter ego trust, joint spousal trust, family trust. So I had a nice lock here because this is a way to lock up assets. They're not wills. So a will can be challenged, like I've been talking about through that particular section of the Wills, Estates, and Succession Act. Trusts are much harder to challenge. We don't have that section that allows spouses or children to challenge them in the same way. So these you actually create during your lifetime so that they come into being during your lifetime, not on your death. And you place significant assets into that trust, and those assets will then eventually pass to beneficiaries named in the trust rather than through the will. So those assets, you've taken them away from your estate, so they're not going to pass through your estate. They're not going to be subject to the will, and so they can't be varied, similar to when you change your tax-free savings account to name a particular child. Okay. These trusts, though, they're administratively complex. You have to file separate tax returns for them, do accountings for them. They are, kind of a pain to run. And depending on the circumstances, they can be taxed at the highest tax bracket. So we usually only recommend these for wealthy individuals, or people who have an extreme need to avoid variation. So there is such a high chance that one of their kids is going to claim. The consequences of one of the kids claiming would be terrible. Maybe this child was a criminal or a drug addict who is going to squander the estate. Um, those are the kinds of cases where we'd say, all right, it may make sense to use this mechanism. It's very effective in blocking a claim, but the administrative and or taxation issues associated with it often put people off of this one. Mutual wills. So this is a tactic where the couples agree within each of their wills that neither can change the will without the consent of the other. So to use Fred and Mary as an example, Fred and Mary might say, let's make wills together. And in that will, we're going to agree that you will not change the will without me. So I will leave everything to you. And then after your death, I will leave everything 50% to your kids, 50% to my kids. And we're going to agree that we cannot change this will without the consent of the other. So what will happen in that case? So let's say Fred and Mary, Fred then, they make these mutual wills. Fred then dies, and then Mary wants to change the will. There's nothing stopping her from actually changing the will. Like she can still go into a lawyer's office and change that will. But Fred's kids are going to have a contractual right as against Mary when she dies to enforce that will against her. So to say, no, Mary, you broke your promise. You are beholden to the mutual will and you need to follow it. The court will not always enforce a mutual will, but it's much more likely than if you don't have a mutual will. And it provides some protection without escalating to the level of actually creating a trust with all those administrative and potential tax issues. So I've seen these become a lot more popular with my clients who don't want to take any sort of really extreme steps, but want some protection. A really important thing with these, though, is you need to make sure that your children are aware that they are mutual wills and that this agreement is in place. If your children are not aware that has been the arrangement, then how will they enforce a right that they don't know that they have? So this works in conjunction with the kids being aware that this has been done. Statutory declarations or explanations. So these don't provide any protection against a claim, but they can weaken the position of the opposing party by showing that the reasons of the deceased were just and prudent. So this is where you would document your reasons for what you did. So if you decided to leave your spouse only $100,000 because they're independently wealthy, you don't have a claim on their assets, you would document that there. Or if your child is a drug addict and can't be trusted with money, and so you have provided their funds to be in a trust for them, this is where you would document that. So documentation can go a long way to showing that if there is a claim, having people back down from that claim by showing that you were just and prudent when you made this decision. Okay, so we're going to talk through how these tools would apply to our fictional people here. And we're going to start with Fred and Mary. I've mentioned them throughout just as a general example. So could a marriage agreement help Fred and Mary? Likely not at this stage. Fred and Mary have been married for a long time. They're in their 80s. It could be done in conjunction with severing some of their assets. But at this point, we think they're pretty far along in their marriage. We could sever their assets, slice the orange, and do a marriage agreement saying, okay, Mary, you have half of the assets, Fred, you have half of the assets, and you do a marriage agreement saying all of Mary's half goes to her kids, all of Fred's half goes to his kids. But that doesn't really help in terms of they want to provide for each other first. They do want each other to have full access until the survivor dies. We could exclude some assets by changing beneficiaries. We talked about that. So Fred could say, I'm going to change my tax-free savings account to name my son. And that will, make sure that at the very least that works. A trust could be appropriate depending on the net wealth of Mary and Fred, but I'm assuming that they're pretty standard folks, not terribly wealthy here. Usually for a trust, it's around $5 million in net worth, where it starts making sense. Below that, it's not common. And a mutual will would help protect too. So they could decide to have mutual wills, each agreeing that they're not going to change these wills without the consent of the other. Okay, so Laura, what could she do? Could she use a cohabitation work agreement? Yeah, possibly. She's only been with Paul for 5 years. Paul might be totally understanding that she's going to leave most of her assets to her children on her death. That could be an option. Severing assets is not a concern. Since Laura doesn't hold anything jointly with Paul at this point, we would want to make sure, though, that she doesn't put anything into joint names with him. Excluded assets can be helpful as well to make sure, if she hasn't already done so, that her tax-free savings accounts, RSPs, life insurance policies name her kids. A trust would be a great idea in this case to protect, provided that Laura, again, has the net worth to justify it. Mutual wills are not helpful since Laura is just doing her planning without Paul. She doesn't necessarily want Paul making a will at the same time as her or in conjunction with her. Okay, Yasmin and Tim. Yasmin and Tim could decide to treat David, the son from the prior relationship, they could decide to treat him equally to avoid a variation claim. So instead of just giving him a paltry 25,000, we're going to treat him the same as the other kids. That isn't what they want, but it would work in terms of making sure that claim isn't going to occur. They could also do a cohabitation agreement to say that they'll provide for their own children separately, sever their assets. Again, like that's the same as Fred and Mary. They could do a marriage agreement and sever their assets at the same time. Most people do not do that just because they're so used to having combined assets and sort of living as a unit that those two in conjunction seem extreme to most of my clients. So like they're there and they do work, but most people don't prefer them. They could also, again, use excluded assets to ensure that the three children they want to provide for will receive more than David, the son they don't want to provide for. So they could make sure that the three kids they raise together are equal beneficiaries on tax-free savings accounts, registered retirement funds, etc. Trust wouldn't make sense here. There's not a huge amount of net worth in this family. If there's very, very bad blood between the siblings, we might consider it, but I think that's probably not the way we want to go. Mutual wills could also help too. It could foster trust between Yasmin and Tim, but it wouldn't necessarily protect the siblings against fighting amongst each other. Okay. Here's another tool. This is not a legal tool, but we're going to talk about it. And this is very important. It's family transparency. So it's not a legal tool of itself, and we're not recommending it as a legal tool. And if you rely only on family transparency, then there is no, legal mechanism to protect you. But you are trusting in a situation of family transparency that they're not going to make claims because everyone has discussed the plan. Everyone has a chance to weigh in, have their opinions heard. This really often helps resolve these issues. Now, it doesn't work for everybody. Some blended families don't have this kind of open relationship, but if there can be a level of transparency, then it really does help. If you know what to expect, if your kids and your family know what to expect in your estate, people have a larger chance of getting along and resolving these issues. So you won't even need these legal tools, or you'll need less of them if you have some confidence that your family understands the plan and what's going to happen. So here's some examples of how we could resolve these things, plus using some family transparency. So as I said before, I'm not recommending any of these particular solutions as like the solution for each of these, but they are some options, and they are the kind of options I commonly see people selecting. So, oh, sorry. So for Fred and Mary, let's say that Fred and Mary decide that their kids get along fairly well, and they would understand that eventually 50% would go to Mary's son and 50% would go to Fred's children. And they discuss this with their children separately, and they get confirmation that all the kids understand that and they think it's fair. So Fred and Mary want to show each other they're both on board and committed to the plan. So they make mutual wills saying the survivor will not change the will without opening a claim against the estate. And they provide copies of those agreements to all the children. That would work well in saying, okay, we agree this is how it's going to be. All the kids know, all the kids have a copy of what's going to happen. We can rely that this is how it's going to go. So Laura. So let's say Laura has a conversation with her boyfriend, Paul, and he totally agrees that Laura should leave the majority of estate to her children. He asks that she give him a little bit more time to stay in the house, not 2 years, but 5. And Laura says that does make sense. And she makes a will giving Paul this right and leaving the rest of her estate to her kids. She signs a declaration explaining that she spoke with Paul about all of this and he agreed at the time. She then ensures that she names her children as the beneficiaries to her tax-free savings account and registered retirement income fund so that those kids will be sure to inherit those usually fairly big ticket items after her death. Laura probably should have insisted in this example on having Paul sign a cohabitation agreement confirming all of this. But a lot of people are really resistant to getting their spouse to sign or their partner to sign something like that after they've been together for several years. So I'm trying to give a realistic example here in that I would advise Laura to get a cohabitation agreement, but the chances of her doing that, I think, are not super high, just given how people generally sort of conduct themselves. Okay, so now we're going to talk about Yasmin and Tim and their very complicated family. So let's say in this example, they agree the best thing to do is to sever their assets to make sure that each of them has his or her own estate. So Yasmin will have half of their assets and Tim will have half of his assets. Each of them is going to leave the other just enough money to get by. So 25% of the estate, and then everything else will go to their own children right away. So they're going to leave enough money that the other can make it if one of them dies, but then everything else would go to their children. And Tim decides he's going to include his son David, who is from the prior marriage or prior relationship, as an equal beneficiary. So if Tim dies first, Yasmin will receive 25% of his estate, and the rest will be divided equally between Tim's kids, including David. So David, Amy, and George. They'll inherit right away. They won't have to wait for Yasmin to die. And then when Yasmin dies, her estate would eventually be divided between her 2 children. And then George, who remember is Tim and Yasmin's son together, so their son together, he will inherit twice, once from Tim's estate and once from Yasmin estates. But that's fair because the other kids will inherit from their other biological parents. And let's say they have a family meeting to discuss it and everyone agrees it's reasonable. They're a bit annoyed that David, the son from the first relationship, is being treated the same as they are, but they understand it. And they work this out and they sign a declaration explaining why they've done it. So that is an option on how this could work out. As you can probably see, Yasmin and Tim and their mixed family is very, it's quite a complicated one. It would take some working through to come up with some options for that, but that is a possible option. Okay, so now I think we have some time for questions. This is my contact information if you want to use it for any reason. Thanks for coming to my presentation. I know it's a lot of information presented quite quickly, so I hope you were able to follow it okay. And yeah, I'll see if there's any questions. And I will stop sharing my screen. There you go.
Thank you so much for that, Raya. Yeah, if anyone has questions, feel free to unmute
Oh, I see there's
yourself.
some in the chat. I
Mhm.
know a couple who stopped living together, but he was still entitled to part of her estate. Yes, that can happen depending on the time. So if you are, okay, so if you're not legally married, so you've never been married, you're living together, um, and then you separate, you have 2 years from the time that you separate to claim. So if this person, they separated from their common law partner, and then they died within that 2 year time frame after separating from the common law partner, yes, there would be a claim against the estate. And then there's also a claim against the estate that can arise when you are legally married. So you've been married, you're legally married, you never get divorced, but you separate. That is another reason that a claim can happen. Because in terms of married couples, it's divorce that like fully severs that inheritance right. And so that can be an issue. It's a little more nuanced than that. It's not really an inheritance right. It's the right to claim for assets in the divorce that were never settled, but in effect, it works similar to an inheritance right. Um, my wife refused to be involved in real estate, so they're all in my name. She refused to extend joint insurance. Oh boy. Um, in that case, this is someone who does not have, the wife's not involved. He has assets in his sole name. And she's not, the wife won't extend insurance to pay for inheritance taxes. How do you make sure that gets to your kids? Yeah, you'd want to look at all of those options in this case, since the wife is not going to be cooperative, family transparency, or a lot of the agreements are probably not going to work for you. This, depending on the net worth, there could be a trust done, definitely excluded assets. So definitely making sure the kids are designated as the beneficiaries on anything they can be. So tax-free savings, life insurance, I guess in this case, the insurance is joint, but anything that you have in your sole name, designate the kids for that. And then yeah, this is not a great one. The real estate would go, because it's in this person's sole name, the real estate would be left to the children if that's how the will says. So if the will leaves everything to the kids, not to the wife, it would go to the children, but the wife would still have a claim against the estate for a greater share. So that's a messy one. I would say for that question, definitely talk to your own lawyer about that, your own estate planning lawyer about options um, there. Any other questions?
Um, my husband and I have children from separate marriages.
Mhm.
We've been married for 20 years, and we have in our wills shared everything equally with our children. If I think things go to me or him if one of us pass away first, but
Mhm.
then the children are they get an equal share.
Yeah,
Um, but we haven't done that extra step that you spoke about today. So this is, we would have to trust each other that we're gonna
yeah,
honor each other's will.
yeah. You're relying right now on good old fashioned trust, which isn't a bad thing. It just, there always is a slight risk. And some of my clients decide, as you do or have at this point, that they don't even want an extra step. They say, no, I trust you so much that you would never, betray our intent. That I am fine going on good old fashioned trust. The the risk that I see is in cases where you actually truly trust each other, it's often not so much do you trust your spouse, but do you trust that your spouse would not get into another relationship if you predecease them, or that that person would not exert influence on your spouse to try to get something. So in a case like that, I have kind of been bringing back the mutual will agreements. They've fallen out of favor a bit, but just having an agreement between each other, and it doesn't have to be super fancy. Your lawyer can likely draw it up, or even if you don't want to get a lawyer involved because you want to save money or whatever, even just writing out between each other in an email or on a piece of paper at home, like,
Oh.
we agree that we are not going to change these wills. We are going to trust each other and remain faithful on that, and that if either of us gets into a prior relationship or another relationship after one dies, that person will take steps to protect from that prior spouse. So the main thing I see with that is good old fashioned trust plus some kind of agreement documented between the two of you that you're not going to do anything like that. And then just remembering, if you are the survivor or if your husband is the survivor, have a cohabitation agreement with any new partner. Do not blindly fall in love and go crazy. And it's also helpful to kind of warn the kids on that too. Be like, hey, like, if you see dad like starting to get on the dating scene, like, remind him, like, don't do it. Yeah.
Okay, good point.
Yeah.
Thank you.
I have a fun little question. Years ago, I signed basically a handcrafted prenup. Does that stand up if
Kind of.
if anything legal were to happen?
Yeah. So I don't know if it was yours or someone else's. Were you a witness or was it your own?
It was my own, and
It
it
was your
was
own.
just like a handwritten letter saying like, I'm not going to take anything from this family.
Oh,
Okay. Yes, but it's harder. So,
Yeah.
the Family Law Act, which is what governs prenups or cohabs, things like that, says that the court will consider, and they say consider, not enforce. So they will consider any agreements between the couple on how things are going to unfold. Um, and then it will set out in the Family Law Act sort of the thresholds for when the court can just throw the whole agreement out. So for an agreement that is lawyer drafted, so it's lawyer drafted, lawyer witnessed, it's, more ironclad,
Yeah.
the threshold is much higher. So the court in that case will say, I will not throw this out unless there was like actual evidence of coercion, undue influence, like unfair bargaining power, like something
Mm.
really egregious.
Yep.
In a handwritten note or self-drawn document, the threshold is a bit lower. So the court can say, can throw this out if it just doesn't make any sense
Yeah.
in conjunction with legal norms or legal practices. And again, like the main things that would impact something like that, like a hand-drawn one from, I assume, like an earlier marriage, is how much have things changed in your life. So,
Yeah.
if you were with this person for 5 years and you're now getting divorced, yeah, probably they'd say fair enough. Like, it was only 5 years long. Like, if it's not out of line with our sort of understanding of legal norms to say that you're not going to be getting anything. If you're married 30 years and you've got two kids and a pet together and a mortgage, it's a lot harder. It also depends on whether it's against you said family. So
Mm.
against a family, it's harder. So if it was a situation where your partner was trying to protect, like it was her parents, or trying to say like you're not going to come after against anything in the family,
Yep.
that is a weirder one because you're not really entitled to anything from her family anyway. You're
Yeah.
only entitled to things that are hers.
Yeah.
So like
That's what
you
made it
would
extra
never,
funny.
yeah, you would never be entitled to, like, if her parents were wealthy, or she had a family trust that was, locked up by her grandparents. Like, you're not entitled to that stuff anyway. It's not
Yeah.
yours. They might have been trying to protect against a situation where they have family money, they're giving it to her as a gift, and they want to know that if you were to divorce, that gift is coming to her, not to you in the
Yep.
case of a divorce. That is a fairly common one where parents will have a documentation saying, like, I'm giving money to this couple, but it's really for my daughter. And if you guys get divorced, it comes back to my daughter. Um,
Yep.
that's common, but it also it's provided for in the law anyway. Something like that would definitely not be out of legal norm, in that the Family Law Act actually provides that anything that you receive as an inheritance or a gift from your family is not divided in the divorce.
Mm.
So let's say she got $100,000, and 20 years later you guys get divorced. With the proper documentation, we'd say, yeah, it comes back to her. So the $100,000 that she got from her parents is not included in the divorce. She gets that out. Any increase in value, so if you took that $100,000 and you put it into the house, and the house is now, 1.5 million, and you can attribute like a percentage of that growth to the 100,000, like you would still share in that. That's still divisible with you.
Yep.
But that 100 grand that they put in for her, like she would get that back out, and then the remainder would be divided equally. So that's a common one.
Makes sense. Yep. That pretty much covered everything I was considering.
There you go. Yeah, you're probably I've seen those where, the father-in-law will
Yeah.
slip the note to be like, you gotta sign this.
Yeah, that's essentially what happened.
Yeah.
He was just protecting future possibilities, which I
Yeah,
wasn't
and
ever
I'd
gonna
say
do
like it
anything.
is for parents, that is a good thing to do
Yeah.
when you're watching it, even though it is provided in the family law anyway. It's just really helpful to have that extra documentation to show that was the intent, and have your in-laws be accountable for that. If you don't do that, yeah, things can get nasty. I had a family member getting divorced. The parents did not document that. And yeah, the money was gone because there was a claim that it was a gift to both parties, not to
Yeah.
one party. So if if you're putting down money for your children or child and their partner, spouse to buy a home, and
Yep.
the home is going into joint names, yeah, you do want some documentation to show this was a gift to my daughter, not to my son-in-law as well, because in the absence of that documentation, there can be a claim that no, in fact, when they put down that $100,000, they meant 50 to me and 50 to her.
Yep.
Yeah.
I could see that happening really easily. All right.
All right, no other questions. So yeah, we'll move on. Yeah, there's a lot of information in here, so hopefully you digested it pretty well. It can be a challenging topic.
Yeah.
And I'd say the best thing to do for any like specific questions is, yeah, discuss them with your own lawyer, your own family, and figure out what works for you.
Awesome. Thank
Hey,
you so much
thank
for
you
that,
so
Raya.
much.
Yeah,
Might see you next year for topic unknown.
Yeah. Yeah, it would be wonderful to have you back.
yeah,
Okay,
thank you, Raya.
Yeah, you're welcome. Bye.
Thank you,
Okay,
Raya.
bye-bye.
Bye, everyone.